walked there as a child. She had walked there with her uncle, who had pointed out the trees he had planned and the paths that would be laid, and the places where families would come to sit in the grass on summer afternoons. She carried those walks with her the way you carry the memories of time spent with people who are gone, not painfully, or not only painfully, but with the particular sweetness of knowing that you had the time you had, and that it was real, and that nothing and no one can take the realness of it from you. She rebuilt, slowly, with the patience of someone who has learned that rebuilding is not a dramatic event, but a daily practice. She rebuilt a life that was smaller than the one she had imagined for herself, and in some ways richer, in the way that lives stripped of pretensions sometimes become richer, in the way that surviving something terrible can clarify what actually matters. She never spoke publicly about her private knowledge of what Hyde had done. She never gave an interview. She never wrote a memoir. She maintained, to the end of her life, the particular dignity of a woman who has decided that her private understanding is hers, and that the public does not have an automatic right to it simply because the public was interested. She had given enough to the public. She had sat in that courtroom and been looked at and speculated about and analyzed, and she had given, in that sitting and in that endurance, more than most people are ever required to give. What she kept was hers. The city that had watched her so closely eventually turned its attention elsewhere, as cities do. New stories, new dramas, new trials and tribulations demanded the column inches and the dinner table conversations that the Swope case had once commanded. Frances became, gradually, a private person again, which was perhaps the best outcome available to her, the outcome she had been working toward through all the years of exposure and scrutiny. She lived a long time. She outlived Hyde by decades. She outlived some of the nurses and physicians and attorneys who had been present at the trial. She outlived some of the jurors. She outlived, in a sense, the story itself, or at least the version of the story that the public had been most interested in, the version centered on the courtroom and the verdict and the reversal. The version of the story she lived with privately, the version that contained her own knowledge and her own reckoning and the particular texture of her daily experience of what had happened. That version she carried to her grave, intact, unshared, hers, and yet something remains. Something in the outline of her choices, in the sequence of her decisions, in the gradual arc from the secret marriage to the public trial to the private divorce to the quiet rebuilding. Something in all of that tells a story that is worth hearing. It is the story of a woman who was placed by circumstance in an impossible position and who navigated it with more grace than the position deserved. Who loved someone she should not have loved, and who paid for that love in ways that were not her fault, and that were not fair. Who eventually found the courage to name what she knew. Even if the naming happened in action rather than in words. Even if the divorce was the sentence that contained all the other sentences she never spoke aloud. It is the story of a woman who survived. In a case full of people who did not, that is not a small thing. It is not a small thing to survive what Frances survived. It is not a small thing to come out the other side of something that large and that terrible and to find, in the wreckage, the materials for a life that is still worth living. She found them. She built with them. She lived. And in the park that still bears her uncle's name, in the green and permanent gift that the colonel gave his city, the trees he planted and the paths he imagined and the open sky above it all remain exactly as they were, waiting for anyone who needs them, open to anyone who comes, asking nothing in return except the willingness to simply be present in a place that was made by a generous and complicated and trusting man for that exact purpose. Frances walked there. After everything, she walked there in the quiet mornings when the city was still waking and the light was new and the grief was still there but had become, with time, something she could carry rather than something that carried her. She walked in her uncle's park, and the trees did not know her story, and the grass did not know her name, and the sky above asked no questions that she was not ready to answer. And that was enough. For now, that was enough. There is a kind of courage that nobody writes songs about. It does not announce itself with flags or fanfare or the particular dramatic clarity of a moment that everyone present recognizes as historic. It operates quietly, in the margins of events, in the small daily decisions of ordinary people who are placed by circumstance in situations that require them to see things clearly and hold what they see with great care and weight, with the patience that very few people actually possess, for the moment when what they are holding can do some good. It is the courage of witnesses. The courage of people who know something and who understand, in their bones, that the knowing is only the beginning, that what comes after the knowing is harder than the knowing itself, and who choose to stay anyway. Pearl Keller had that courage. She was a nurse. In 1909, nursing was a profession that existed in a complicated social space, a profession that was simultaneously respected for its essential function and underestimated for the intelligence and observational skill it required. Nurses were expected to be present and attentive and capable and discreet, and the discreet part was emphasized in ways that the other parts were not, because discreet meant that they did not challenge the authority of physicians, did not offer opinions that conflicted with medical diagnoses, did not carry the details of what happened in sick rooms out into the world beyond those rooms. They were witnesses by vocation and silent by convention, and the convention was enforced not by any written rule, but by the invisible architecture of a professional hierarchy that placed physicians at the top and nurses somewhat below, and expected everyone to understand their place within that architecture without being told. Pearl Keller understood her place. She also understood that her place was not the same as her obligation. And when those two things came into conflict, when what her professional position required of her and what her conscience required of her pointed in different directions, she made a choice. She chose her conscience. Not immediately, not with the dramatic decisiveness of a movie heroine, but gradually and carefully, and with the particular kind of resolve that builds itself one small decision at a time until it becomes something that cannot be undone. She had been hired in September of 1909 to care for Colonel Swope following his fall. She arrived at the mansion with her nursing bag and her professional composure and the efficient, warm manner that good nurses develop over years of sitting with sick and frightened people. And she settled into the household rhythms with the practiced ease of someone who has done this many times before in many different households. She had met Bennett Clark Hyde within her first days in the mansion, and she had formed, in those first days, the kind of preliminary impression that experienced nurses form about the physicians they work alongside, an impression that is not yet a judgment, but that has its own texture and its own weight. She noticed, in those early days, that Hyde was attentive in a way that went slightly beyond what the medical situation required. He visited the colonel frequently. He involved himself in decisions that might reasonably have been left to the regular household physician. He was, in the specific manner of someone performing competence rather than simply being competent, very visible. He made sure that people saw him caring for the colonel. He made sure that the colonel knew he was there, that the old man felt tended and attended, that the relationship between patient and physician was being actively and visibly maintained. This is not, on its own, suspicious behavior. Attentive physicians exist. Physicians who are genuinely dedicated to their patients exist. The behavior Pearl Keller was observing in those early September days could have been interpreted as the behavior of a conscientious doctor, and she did interpret it that way, initially, because conscientious doctors were the category available to her, and there was not yet any specific reason to reach for a different category. But she was watching. This was what Pearl Keller did with a thoroughness that most people in her position did not bring to it. She watched. She filed. She retained. She built, in the careful archive of her professional memory, a record of everything she observed in that household that was precise enough and detailed enough to be retrieved intact months later, in a coroner's office and then in a courtroom, with a specificity that would make it almost impossible to dismiss. The first thing that shifted her preliminary impression was the death of Moss Hunton. She had been present. She had watched Hyde bleed the man. She had been in the room when Dr. Twyman gave his instruction, 1 pint, no more, and she had noted Hyde's response to that instruction, which was the response of a man who agrees with a directive he does not intend to follow, the particular smooth, professional acquiescence of someone who has already decided what they are going to do and is simply managing the optics of the disagreement. She had watched Hyde continue after Twyman left. She had watched the blood. She had watched Moss Hunton die. In her professional experience, patients died. This was a fact of the work, an unavoidable and recurring feature of a vocation spent in proximity to human vulnerability. People got sick, and sometimes the sickness was stronger than the medicine, and the person died. She had sat with many people in their final hours, and she had developed the particular equanimity of someone who has made her peace with mortality as a feature of the human condition rather than as a failure or a surprise. She did not respond to death with shock. She responded to it with the quiet, professional composure that the people around her needed from her. But the death of Moss Hunton was not the death of someone whose sickness had been stronger than the medicine. It was the death of someone whose physician had exceeded the boundaries specified by a more senior doctor, who had taken 2 quarts of blood from a man who had been told to give only 1 pint, who had done this in the absence of the physician who had given the instruction and had therefore done it without witness and without accountability. This was not a death that Pearl Keller could file under the ordinary category of medical tragedy. This was a death that sat at the edge of a different category entirely, a category she was not yet ready to name, but that she could feel taking shape at the periphery of her professional understanding. She said nothing. Not yet. Because saying something required her to have something specific to say, something that went beyond a feeling of wrongness and a set of observations that could, individually, be explained away. She did not yet have that. She had pieces. And she understood that pieces, in the absence of a pattern that connected them, were not sufficient to do what she was beginning to understand might need to be done. She kept watching. The death of the colonel, 2 days after Hunton's death, gave her more pieces. She was present for the tablet. She was present for the convulsions. She was present for the colonel's last words. And she was present, crucially, for Hyde's response to what was happening, for the composed, unhurried manner of a man who was not alarmed by what he was witnessing, who did not reach for the telephone to call another physician, who managed the situation with the particular control of someone who already knows how it is going to end. That was the piece that fit. That was the specific observation that connected to the other specific observations in a way that produced, for Pearl Keller, a pattern she could no longer interpret as coincidence. 2 men, both in Hyde's care, both dying following medical interventions by Hyde, both dying in ways that contradicted the official diagnoses Hyde had offered, and Hyde, at both deaths, displaying a composure that read less like the steadiness of an experienced physician and more like the steadiness of a man who is watching something unfold according to a plan he has made. She still said nothing, because she still did not have what she needed to say it effectively. She had her observations and her pattern recognition and the deep conviction of a woman who has spent her professional life learning to read the signs that bodies and circumstances emit when something is wrong. But she did not have evidence. She did not have the specific, verifiable, documentable evidence that the law would require, that a coroner would require, that the family would require before they could act. And so she did the thing that required, in its own quiet way, the most extraordinary courage of all. She stayed. She stayed in that house, in that household, in the daily proximity of a man she had come to believe was a murderer, and she continued to do her job. She continued to care for the patients in her charge. She continued to observe, with the patient, methodical attention of someone who understands that the evidence she does not yet have is still being generated, is still being created by the ongoing behavior of the person she is watching, and that her job is to be present and attentive when it appears. Through the typhoid outbreak, she stayed. Through the weeks in which family member after family member fell ill with a progression and a pattern that did not align with what a natural typhoid outbreak typically looked like, she stayed and she watched and she noted. She noted the capsules, the specific instances when Hyde produced small capsules and administered them to patients in the moments between other medical staff's visits, in the particular private interstices of caregiving when a physician and a patient are briefly alone. She noted which patients received them. She noted what happened to those patients in the hours that followed. She noted Hyde's behavior on the evening that Chrisman Swope died. She noted the composure. She noted his departure to the banquet. She noted everything with the precision of a woman who has decided that what she is observing must be preserved exactly as it is, without interpretation and without embellishment, in the precise form of witnessed fact, because witnessed fact is what the law will eventually need, and she intends to give the law exactly that. When the family began to act, when Margaret began to speak to attorneys, when Tom Swope brought the capsule fragments in from the snow, when the decision was made to pursue an investigation, Pearl Keller was ready. She was more than ready. She had been ready for weeks, carrying the precise and detailed account of what she had seen in the careful interior archive she had been building since September, waiting for the moment when someone with the authority to act would create the space in which her testimony could matter. She went to the investigators. She sat down with them in the formal, careful way of a professional woman of her era, and she described in sequence and in detail, everything she had witnessed since her arrival at the Swope mansion. She described it without dramatization and without emotion, and without the particular embellishments that anxious witnesses sometimes add to their accounts in the belief that they are making the story clearer when they are actually making it less reliable. She described exactly what she had seen and exactly when she had seen it, and exactly who else had been present, and she distinguished, throughout, between what she had directly observed and what she had inferred, maintaining that distinction with a rigor that would later make her testimony almost impossible to effectively challenge. The investigators who heard her initial account understood immediately what they had. A trained professional observer who had been present throughout the period in question, who had no financial stake in the outcome of the investigation, who had no prior personal conflict with the accused, and who had been maintaining a detailed and precise mental record of everything she had witnessed for weeks before anyone asked her to. This was, in the evidentiary terms of a criminal investigation, something genuinely rare. Something genuinely valuable. Pearl Keller was the kind of witness that prosecutors spend careers hoping to find. When she took the stand at trial, the courtroom's attention shifted. There were jurors who later said that Pearl Keller's testimony was the turning point for them. The moment when the accumulation of physical and chemical evidence was given its human frame, when the things that had happened in the Swope mansion were described by someone who had been there and who spoke with the quiet authority of a woman who has nothing to prove and nothing to hide. She was not performing. She was not seeking sympathy. She was not reaching for effect. She was simply telling the jury what she had seen, in the precise and detailed language of professional observation, and the precision itself was its own argument. The defense cross-examined her with the particular intensity they reserved for witnesses they understood were damaging. They questioned her memory. They questioned the accuracy of her perceptions in a situation that was medically complex and emotionally charged. They suggested that she had been influenced by the family's pre-existing suspicions of Hyde, that her account reflected what she had subsequently been told and believed rather than what she had actually observed in real time. She held with the particular steadiness of a woman who knows what she saw and who does not require external validation to maintain that knowledge. She acknowledged the small inconsistencies that existed in her account, the ordinary inconsistencies of honest memory, without apologizing for them, and without allowing the defense to use them to suggest that her entire account was unreliable. She distinguished, again and again, between what she knew and what she believed, between what she had directly witnessed and what she had concluded, with a precision that the defense found difficult to exploit because it left them with very little daylight between her and the truth. The jury believed her. The jury, which deliberated for 3 days before returning its verdict, believed Pearl Keller in the specific and practical sense that their deliberations produced a guilty verdict, which means that the 12 men in that room found her account more credible than the alternative narrative offered by the defense. That is the legal meaning of being believed, and Pearl Keller had earned it. When the conviction was overturned, Pearl Keller was asked to testify again. She agreed. When the case moved through its additional trials and its prolonged legal proceedings, she remained available. She did not withdraw. She did not tire of the process in the way that many witnesses tire of being called back repeatedly to relive experiences they are trying to move past. She understood that what she had witnessed created an obligation, and she honored that obligation with a consistency that did not waver regardless of how many times the legal process demanded it of her. Her life outside the courtroom continued. She worked. She nursed other patients in other households and brought to those situations the same careful, attentive professionalism she had always brought, the same capacity for observation and the same commitment to the people in her care. She was, in the ordinary texture of her daily professional life, exactly what she had always been, a skilled and dedicated nurse who happened, by the accident of circumstance, to have been placed in a position of historic significance. She did not seek recognition for what she had done. This was not false modesty or the performance of humility. It was the behavior of a woman who understood that what she had done was simply what the situation required, that it was the natural extension of her professional commitment to the well-being of the people in her care, that it was, in the most fundamental sense, her job. The colonel had been her patient. Chrisman Swope had been her patient. The family members who fell ill during the typhoid outbreak were, in her professional understanding, her responsibility. She had done what you do when the people in your care are being harmed. She had watched, and she had remembered, and she had spoken when speaking could do something. That is not heroism in the dramatic sense. It is something quieter and more durable. It is the kind of character that does not require a crisis to reveal itself, because it is the same character that shows up every day in the small and unglamorous work of caring for people who need to be cared for. The crisis simply made it visible. There were other nurses. There were women who had also observed things in the Swope household during those autumn and winter months of 1909 who also testified to what they had seen. Some of them had observed the capsules. Some of them had observed Hyde's behavior around specific patients at specific times. Some of them had noted the pattern of who got sick and when, and following what contact with Hyde. Each of their accounts added something. Each of them contributed to the structure of the prosecution's case in ways that were real and significant. But Pearl Keller was the one who had been there from the beginning. Pearl Keller was the one who had watched Moss Hunton die and had stayed. Who had watched the Colonel convulse and had stayed. Who had moved through the typhoid outbreak with her eyes open and her memory running and had stayed. She was the continuous thread through the entire sequence of events, the single witness who had been present for all of it, from the September fall that brought her to the mansion to the winter evidence that brought the investigators. She was the reason the case had the shape it had. Without her testimony, the physical and chemical evidence would have been harder to frame. The laboratory analyses of tissue samples and capsule fragments would have existed in a context without narrative, without the human account that explained what the chemistry meant in terms of what had actually happened to actual people in actual moments that someone had actually witnessed. Pearl Keller was the narrative. She was the human frame around the science. She was the reason the jury could look at the strychnine in the Colonel's liver and understand not just what it meant chemically, but what it meant in terms of a specific old man who had trusted a specific younger man and had taken a tablet from his hand on a specific evening and had convulsed and had spoken the words that everyone in that room would carry for the rest of their lives. Without Pearl Keller, the case was evidence looking for a story. With Pearl Keller, the case was a story that the evidence confirmed. She was not famous. Her name did not become a byword for courage in the way that some witnesses' names do, in the way that the legal history of a case sometimes elevates a particular figure into a kind of permanent cultural memory. She returned to her life and her work and the ordinary daily business of being a nurse in Kansas City in the early 20th century, and she aged and eventually died in the quiet, private way of people whose significance was real but whose profile was low. But in the historical record of the Swope case, her name is there. It is there in the trial transcripts and in the newspaper accounts and in the secondary histories that researchers have written about the case in the decades since. Pearl Keller is there, on the stand, in the specific and detailed language of her testimony, describing what she saw with the precision of someone who understood that precision was her gift to the truth. And the truth, even when the law was unable to fully honor it. Even when the conviction was overturned and the charges were dropped and the man she had watched move through that household walked away legally free, the truth did not disappear. It persisted in the record, in the transcripts, in the accounts she gave, in the accounts that other people gave corroborating hers, in the tissue samples, in the capsule fragments, in the laboratory analyses, in the pattern that everyone who looked at the evidence clearly enough could see. The truth persisted. And Pearl Keller had helped to make sure it would. She had stayed in that house when she could have left. She had watched when it would have been easier not to watch. She had spoken when speaking was uncomfortable and uncertain and professionally risky. She had testified again and again, through every iteration of the legal proceedings, with the same careful precision and the same quiet refusal to embellish or to exaggerate or to make the story larger than what she had actually seen. She had done her job. In a case full of people who had failed to do theirs, who had failed to ask the right questions at the right moments, who had failed to look carefully at what was happening around them, who had failed to act on what they suspected until the acting was already very late. Pearl Keller had done her job with a completeness and a dedication that the case did not deserve, but that the truth required. And somewhere in that, there is something worth holding on to. Something about the ordinary, unglamorous, daily practice of being the kind of person who pays attention, who notices, who remembers, who speaks. It is not nothing to be that person. It is, in fact, in a world where the alternative is very easy and very common, quite a remarkable thing. Pearl Keller was that person. And the colonel, who had trusted the wrong person and had paid for it with everything he had left, deserved at least to have someone like her in the room. At least he had that. There is a moment in every great trial where the human drama pauses and the science takes the stage, and the courtroom, which has been running on emotion and narrative and the particular electricity of human testimony, has to shift registers entirely. The jurors who have been leaning forward to catch the expressions on witnesses' faces and listening for the tremor in a voice that might indicate concealed knowledge. Those same jurors now have to sit back and become students. They have to follow an argument that operates in a different language entirely, a language of molecular weights and chemical reactions, and the specific behavior of organic compounds in biological tissue, a language that most of them have never spoken and that they are being asked not merely to understand but to evaluate, to weigh one expert's version of it against another expert's version and to determine, with their collective non-specialist judgment, which version is more credible. This is one of the hardest things a jury is ever asked to do. And in the trial of Bennett Clark Hyde in the spring of 1910, it was the thing that the outcome of the case, at its deepest level, depended upon. Because the physical evidence was everything. The human testimony was powerful and credible, and it shaped the narrative in ways that mattered enormously. But the human testimony alone would not have been sufficient. The human testimony described behavior. It described a pattern of presence and absence, of capsules administered in private moments, of a physician who stayed calm when calm was the wrong response, and who left for a banquet on the night a young man died in convulsions. These were damning things. These were things that told a story, but they were not proof. They were not the specific, verifiable, scientifically grounded proof that a murder charge requires. The proof that says not merely that something wrong appears to have happened, but that a specific compound was introduced into a specific body and that the introduction of that compound is what caused the death. That proof lived in the laboratories. It lived in the tissue samples and the capsule fragments and the vomit collected from a young woman who had survived because her body had expelled the thing that had been given to her. It lived in the instruments and the chemical processes and the professional expertise of the men who had examined those samples and who were now standing in a courtroom trying to translate their findings into language that 12 ordinary citizens could follow and evaluate and ultimately use to make a decision that would determine whether a man spent the rest of his life in prison. Strychnine was the primary poison at issue. It had been found, in quantities that the prosecution's experts described as representing nearly double the fatal dose for an adult man, in the liver tissue of Colonel Thomas Hunton Swope. The liver, as the body's primary organ of chemical processing, receives everything that enters the bloodstream and works to metabolize it, to break it down into compounds that can be excreted or used. When a poison enters the body, the liver is often the first organ to receive the full concentration of it. And when death occurs quickly enough that the liver has not had time to fully metabolize the compound, that compound remains in the liver tissue in a form that forensic chemists can isolate and identify, sometimes months or even years after the death itself. This is what had happened with the colonel's liver. The strychnine had been administered in a quantity large enough that the colonel's death had been relatively rapid enough that the liver had not had sufficient time to fully process the compound before the body's vital functions ceased. And so the strychnine remained, waiting in the tissue with a patience that its administrator had not anticipated, waiting for the moment when someone would come looking for it with the right tools and the right knowledge and the will to understand what they found. The prosecution's primary expert witness on the question of strychnine was a man of considerable professional standing, a toxicologist whose credentials included both academic appointments and extensive experience in forensic analysis. He took the stand with the particular authority of someone who has spent a professional lifetime developing expertise in a specific technical field and who is very comfortable explaining that expertise to non-specialists, because explaining it to non-specialists is a significant part of what his career has required of him. He described strychnine in terms the jury could follow. He described it as an alkaloid compound, derived from the seeds of the Strychnus nux vomica tree, a plant native to India and Southeast Asia that had been known since antiquity for both its medicinal and its lethal properties. In small doses, strychnine had been used medicinally throughout the 19th and early 20th centuries as a tonic, a stimulant, a treatment for various conditions including constipation and certain forms of paralysis. It appeared in patent medicines and in the pharmacopoeias of that era as a legitimate pharmaceutical compound, which meant that it was not difficult to obtain and that a physician would have entirely unremarkable access to it. In larger doses, it killed. Its mechanism of action was specific and terrible. It blocked the glycine receptors in the spinal cord, the receptors responsible for inhibiting muscle contraction, and the result of that blockage was the uncontrolled, violent contraction of all the voluntary muscles of the body simultaneously. The convulsions that resulted were characteristic and unmistakable. The back arched, the limbs contracted, the face contorted. The spasms came in waves, each one stronger than the last, until the respiratory muscles were seized and breathing became impossible and death followed from asphyxiation. The entire process could unfold within minutes of ingestion of a sufficient dose, which explained the speed with which the colonel had deteriorated following the tablet Hyde had given him. The expert described the specific tests used to identify strychnine in biological tissue. He described the color reactions that strychnine produces when exposed to certain chemical reagents, the specific purple color that develops when strychnine is treated with sulfuric acid and potassium dichromate, a reaction that is distinctive enough to serve as a reliable identification test. He described the crystallization patterns that strychnine produces when isolated from tissue and allowed to form crystals, patterns that were as specific and identifiable as a fingerprint. He described the quantity found in the colonel's liver and the calculation that converted that quantity into the equivalent dose that would have been administered, and he presented that calculation to the jury in the precise and confident terms of a man who has done this work many times and who is not uncertain about his conclusions. The jury listened. Some of them took notes. Some of them nodded in the slightly tentative way of people who are following an argument without being entirely sure they could reproduce it if asked to. But the overall impression conveyed by the expert's testimony was clear enough. A specific poison had been found in a specific body, in a quantity that exceeded the lethal dose, and the expert could explain precisely how he knew this and precisely what it meant. Then the defense's chemistry experts took the stand. The defense had understood, from the beginning of the case, that the chemistry was its greatest challenge. The physical evidence, the tissue samples, the capsule fragments, the laboratory analyses, was the part of the prosecution's case that was most difficult to dismiss with alternative narrative. You could suggest that witnesses had misremembered or had been influenced by pre-existing suspicions. You could suggest that the financial motive was less clear-cut than the prosecution portrayed. You could suggest that the pattern of deaths, while admittedly troubling, was the kind of pattern that sometimes emerges from genuine medical tragedy rather than deliberate murder. But it was much harder to suggest that the strychnine in the colonel's liver was anything other than strychnine, because strychnine is what the chemistry said it was. Harder, but not impossible. The defense had found the argument, and it was not a frivolous one. It was grounded in real scientific uncertainty, in the genuine limitations of forensic chemistry as it existed in 1910, in the authentic complexity of isolating and identifying specific compounds from biological tissue that had been buried in the ground for weeks before anyone thought to examine it. The defense's primary chemistry expert was himself a credentialed professional, a man whose academic qualifications were comparable to those of the prosecution's expert and whose courtroom manner conveyed the same kind of technical authority. He acknowledged, because he had to acknowledge it, that the tissue samples had tested positive for strychnine under the standard chemical tests. He acknowledged that the color reactions and the crystallization patterns that the prosecution's expert had described were consistent with the presence of strychnine. What he challenged was the interpretation of those findings, and specifically the certainty with which the prosecution's expert had attributed the strychnine to deliberate poisoning rather than to some other source. He raised the question of ptomaines. Ptomaines were compounds produced by the decomposition of biological tissue, compounds that had been studied and characterized in the decades preceding the Swope case, and that were known to sometimes produce chemical reactions that mimicked those of true alkaloid poisons under certain testing conditions. The science of distinguishing ptomaines from true alkaloids was, in 1910, still developing, and there were documented cases in which forensic analysts had identified what they believed to be alkaloid poisons in decomposed tissue, and had subsequently been shown to have been detecting ptomaine compounds instead. Could the strychnine identified in the colonel's liver, the defense expert suggested, have been a ptomaine compound that had mimicked strychnin's chemical signature under the testing conditions used? Could the decomposition of the tissue during the weeks between the colonel's burial and his exhumation have produced compounds that had interfered with or confounded the analytical results? These were genuine scientific questions. They were not invented by the defense purely for litigation purposes. They reflected real uncertainty in the forensic science of the era, real debates that were happening in the scientific literature and in the professional community of forensic chemists about the reliability of alkaloid identification in decomposed biological tissue. The defense was not fabricating a controversy. It was identifying a genuine one and deploying it in the context of a criminal trial where the standard of proof was beyond reasonable doubt and where genuine scientific uncertainty, if it could be established, was the equivalent of a key that could open the door to acquittal. The prosecution's expert returned to the stand to rebut. He had been waiting for this argument, and he had prepared for it with the thoroughness of someone who understood that it was coming. He walked the jury through the specific distinctions between ptomaine reactions and true alkaloid reactions under the tests he had employed. He described the additional verification steps he had taken specifically because of the known limitations of the standard tests, the additional chemical analyses and physical examinations of the isolated compounds that he had performed in order to rule out ptomaine interference. He was confident without being dismissive, authoritative without being contemptuous of the defense expert's concerns, precise in a way that communicated genuine mastery of the subject. The jury sat with the competing expert testimonies and tried to evaluate them. This is the impossible task that courts regularly impose on lay people, the task of adjudicating between competing technical expert opinions in fields where they have no independent expertise and no basis for evaluation beyond the apparent authority and credibility of the experts themselves. The prosecution's expert was slightly more senior. The prosecution's expert had performed additional verification steps. The prosecution's expert had been, in the overall quality of his presentation, slightly more convincing. These were the kinds of marginal assessments that jurors make when they are doing the best they can with the tools available to them. And in this case, the marginal assessment broke in the prosecution's favor. But the strychnine was only one part of the chemical story. There was also the cyanide. And the cyanide raised its own complex and contested scientific questions that played out in the courtroom with a drama that the newspapers covering the trial found irresistible and that the jury found genuinely difficult. The cyanide had been found, you will remember, in the capsule fragments that Tom Swope had retrieved from the snow beneath the street lamp, where he had watched Hyde crush something under his boot. The smell had been the first identification, the sharp, almond-like odor that cyanide compounds tend to produce, and that people who have been trained to recognize it can identify reliably. The laboratory confirmation had come from the chemical analysis of the fragments, which had tested positive for potassium cyanide. The defense offered what they called the cockroach theory. Potassium cyanide was used, in that era, as a household pesticide, a compound applied in various forms to kill cockroaches and other vermin. A capsule containing potassium cyanide might therefore, the defense argued, be a pest control device rather than a murder weapon. Hyde might have been crushing such a device in the snow for any number of innocent reasons, none of which needed to have anything to do with the administration of poison to a patient. The prosecution responded that the specific form of the capsule fragments was not consistent with a commercial pest control product, that the size and composition of the fragments matched more closely the pharmaceutical capsules that physicians use to administer medications, and that the presence of such a capsule in Hyde's possession at that specific time and in that specific place was not consistent with pest control activity. The defense offered the embalming fluid theory for the cyanide found in the tissue samples. This was perhaps their most technically sophisticated argument, and it deserves careful attention. The embalming fluid used in that era typically contained formaldehyde and various other compounds. Under certain conditions, these compounds could interact with the tissues and the naturally occurring substances in them to produce cyanide-containing byproducts. The defense's chemistry expert described this reaction pathway in technical detail, citing published scientific literature that documented the occurrence of such reactions and arguing that the cyanide detected in the Swope tissue samples might have originated in the embalming process rather than in deliberate poisoning. It was a credible enough argument that the prosecution could not dismiss it outright. What they could do, and what they did, was challenge the specific conditions under which the reaction the defense described typically occurred, and demonstrate that those conditions did not align with the specific circumstances of the swope autopsies. The quantities of cyanide compounds found in the tissue samples were, the prosecution's expert argued, far greater than what the embalming fluid reaction pathway could reasonably have produced. The distribution of those compounds within the tissue was inconsistent with what would be expected from a post-mortem chemical reaction and more consistent with what would be expected from pre-mortem exposure to a significant dose of cyanide. The jury listened to all of this. They listened to days of technical testimony, to experts and counter-experts, to qualification and rebuttal, and the particular kind of intellectual combat that scientific disagreement produces when it is staged in a courtroom under adversarial rules of engagement. They listened and they tried to understand and they took notes and they asked, through the judge, clarifying questions that revealed both their genuine engagement with the material and the limits of their ability to evaluate it independently. And through all of the chemistry, through all the molecular weights and reaction pathways and questions about decomposition products, they kept coming back to the things that the chemistry could not explain away. The pattern of who died and when and following what contact with Hyde. The pattern of how the deaths aligned with the financial stakes. The pattern of Hyde's behavior at each death, the composure, the refusal to summon additional physicians, the departure to the banquet. The pattern of the capsules observed by multiple independent nurses in multiple private moments. The pattern that the chemistry confirmed rather than created, that gave the human testimony its scientific foundation and gave the scientific evidence its human meaning. The defense expert on typhoid fever was the final major scientific witness. He was called to address the typhoid outbreak specifically, to provide the alternative explanation that natural disease rather than deliberate contamination had produced the cases that swept through the Swope household in November and December of 1909. He described typhoid fever's natural epidemiology in the careful, technical terms of a physician who genuinely understood the disease, and he argued that the outbreak in the Swope household was consistent with a natural occurrence of the kind that had been observed in many households of that era. He argued that the pattern of infection was not so specifically targeted as to require deliberate introduction. He argued that contaminated water supplies and infected food and the role of flies as mechanical vectors were sufficient to explain everything that had occurred. The prosecution came back at him with Dr. Stewart. Dr. Stewart, who had provided Hyde with the typhoid cultures, whose testimony established that Hyde had obtained live Salmonella typhi before the outbreak began, whose account of the request Hyde had made, and the professional context in which it was made, and the research justification Hyde had offered, sat in the courtroom like an immovable object against which the defense's natural epidemiology argument could not help but break. Because the defense's typhoid expert was describing what could theoretically have produced the outbreak, the prosecution was describing what had actually happened in the specific case. A physician had obtained the bacteria, and then the bacteria had appeared in the household where that physician practiced. The gap between theoretical possibility and specific circumstance was the gap that the prosecution exploited with devastating effectiveness, and it was a gap that the defense's expert, however technically competent, was not able to close. The science of 1910 was not the science of today. The forensic chemistry available to the investigators and the prosecution was imprecise by contemporary standards, subject to uncertainties and limitations that a modern forensic laboratory would have resolved with tools and techniques that were simply not available in that era. The tests were real and the results were real, and the experts who performed them were genuinely skilled professionals doing their best work with the best methods of their time. But they were working at the edge of what their discipline could reliably produce, and the defense understood this and used it as effectively as they could. What the science was sufficient to do, even given its limitations, was establish a pattern of chemical findings that was consistent with deliberate poisoning and inconsistent with the official medical diagnoses that Hyde had provided. It could not achieve the absolute certainty of a modern forensic analysis, but it could, and did, achieve the level of certainty that the prosecution needed, sufficient certainty, combined with everything else the case contained, to persuade 12 men beyond a reasonable doubt that what had happened in the Swope mansion was not a series of tragic natural events, but a series of deliberate acts by a man who had decided that a fortune was worth more than the lives of the people who stood between him and it. The chemistry told the story of the body. Pearl Keller told the story of the witness. The financial records told the story of the motive. Tom Swope told the story of the snow and the street lamp. And Dr. Stewart told the story of the bacteria obtained before the bacteria appeared. Together, they told the story of what had happened in the autumn and winter of 1909 in a mansion in Kansas City, where the fires were warm and the silver was polished, and the doctor who had married into the family moved through the rooms with the patient, methodical deliberateness of a man who had made his calculations and was seeing them through. The jury took 3 days to evaluate all of it. 3 days to sit with everything and turn it over and examine it from every angle that 12 different people bring to an examination of the same set of facts. 3 days of the particular difficult work of collective decision-making about something that enormous and that consequential. And then they came back. Guilty. The science had spoken. The witnesses had spoken. The pattern had spoken. And 12 ordinary citizens, asked to translate all of it into the binary language of the law, had found that the translation produced one word and one word only. Guilty. The word landed in the courtroom, and it echoed, and it settled. And the families of the dead, sitting in their section of the gallery, heard it and felt it in the particular complicated way of people who have been waiting for something for a very long time, and who find, when it finally arrives, that it contains both the satisfaction of justice and the recognition that justice, however necessary, does not restore what was lost. The Colonel was still dead. Chrisman was still dead. Moss Hunton was still dead. The science had explained how. The law had attributed the how to a specific who. And the reckoning that followed was both exactly what it needed to be and not nearly enough. It is never enough. That is the thing about murder cases that the law cannot change, no matter how careful the investigation or how convincing the evidence or how clear the verdict. The verdict addresses what the law can address. The grief addresses something else. And the two live alongside each other, the verdict and the grief, in the lives of the people who survive, in the long aftermath of violence that the courtroom cannot reach. The courtroom had done what it could. The science had done what it could. And in the silence after the verdict, in the particular silence that follows the completion of a process that has consumed everything it could consume, the people in that room began the slow return to ordinary life, carrying with them everything they had learned and everything they could not change. There is something that happens to a city when it discovers that the monster did not come from outside. When it discovers that the violence it is processing was not the work of a stranger who slipped in through an unlocked door and disappeared back into the anonymous dark, but the work of someone who had been sitting at dinner tables and shaking hands at civic events and walking the same boulevards as everyone else. Unremarkable, familiar, utterly indistinguishable from the people around him until the moment when the evidence accumulated beyond the point of denial and the truth became unavoidable. That discovery does something particular to a community's sense of itself. It disturbs something foundational. It asks a question that communities are never fully prepared to answer, which is, how did we not know? How did someone capable of this live among us without our knowing? And what does it mean about us, about our capacity for collective perception, that we did not see it? Kansas City in the winter of 1909 and the spring of 1910 was asking those questions. It was asking them in the newspapers, which had been following the Swope case with an intensity that reflected both the genuine public interest in the story and the understanding of editors and publishers that the story was the kind of story that moved papers and kept readers coming back. It was asking them in the parlors and dining rooms and churches of the city's middle and upper classes, who had known the Swope family, or known people who knew them, or attended the same events, or read about Colonel Swope's park donation in the local press, and felt a proprietary pride in his generosity and a proportionate horror at what had apparently been done to him. And it was asking them in the simpler, more direct conversations of ordinary people who had no connection to the Swopes at all, but who understood, in the instinctive way of people who live in a community and feel the events of that community as personal, that what had happened in the Swope mansion was not just a private family tragedy, but something that reached out and touched the shared life of the city. The newspapers were the primary medium through which Kansas City processed the story. In 1909 and 1910, before radio and decades before television, Newspapers were the nervous system of American civic life, the infrastructure through which information moved, and through which public opinion was shaped, and through which events were given their narrative form. The Kansas City papers had been covering the Swope story since the early days of the investigation, and they had been covering it with a thoroughness that reflected their understanding of its significance. Reporters had been present at the coroner's inquest. Reporters had been in the courtroom every day of the trial. Reporters had interviewed family members and neighbors and medical experts and legal authorities, and they had filed daily dispatches that told the story of the investigation and the trial in the serial, episodic manner that newspapers of that era were very good at, the manner that kept readers returning each morning to find out what had happened next in a story that seemed to grow more extraordinary with each development. The coverage was not neutral. Newspaper coverage in 1910 was not the carefully calibrated. Both sides presented objectivity that American journalism would develop as a professional standard over the following decades. The papers had opinions, and they expressed them, editorially, and sometimes in the texture of their reporting, and the opinion of the Kansas City press on the subject of Bennett Clark Hyde was not particularly ambiguous. The man was guilty. The evidence was clear. The trial was a formality that the law required, but that everyone who had been paying attention already knew the outcome of. This was the general tenor of the coverage, and it reflected the general tenor of public opinion in the city as a whole. There were dissenting voices. The dissenting voices tended to be found in the legal community, where the procedural questions that would eventually animate the Supreme Court's reversal were being debated among attorneys and judges who understood the technical requirements of criminal proceedings in ways that journalists and the general public did not. These voices argued, in the measured language of professional legal discourse, that the strength of the public's conviction about Hyde's guilt was itself a problem, that the pressure of overwhelming public opinion on a criminal proceeding was a threat to the fairness of that proceeding regardless of whether the defendant was actually guilty. They argued that the procedural protections that the law imposed on criminal trials existed precisely for situations like this one, situations in which the evidence seemed overwhelming and the public verdict seemed obvious, because those were the situations in which the temptation to cut procedural corners was greatest and the consequences of doing so were most serious. These arguments were largely ignored by a public that was not interested in procedural nuance when there was a murderer to be convicted. They were largely ignored by newspapers that understood their readership's appetite for the story of guilt confirmed rather than the story of legal technicality explored. And they were largely ignored by the broader civic conversation that had formed around the Swope case, and that had reached its conclusions and was not particularly inclined to revisit them. They were not, however, ignored by the Missouri Supreme Court. And the Missouri Supreme Court's eventual decision to overturn the conviction was, among other things, a rebuke to the pressure that public opinion had been allowed to exert on the proceedings. It was the law asserting its independence from the court of public opinion, asserting that the standards it imposed on criminal proceedings were not negotiable regardless of how certain everyone was about the defendant's guilt. This was the right thing for the law to do. It was also the thing that produced the most profound public outrage, because the public had not been following the case in order to have a lesson in procedural jurisprudence. The public had been following the case in order to see justice done, and the reversal of the conviction looked, from where the public was standing, like justice undone. The newspapers reflected this outrage with a thoroughness that was itself instructive about the relationship between press and public in that era. Editorial after editorial condemned the Supreme Court's decision not on legal grounds. Few of the editorial writers had the legal background to assess the decision on those grounds, but on moral grounds. The decision was wrong because Hyde was guilty. Hyde was guilty because the evidence said so. And no amount of legal technicality could change what the evidence said. This was the argument, and it was made with the full-throated conviction of institutions that believed themselves to be the voice of the people and that understood the people to be on their side. The reporters who had covered the trial found themselves in the unusual position of continuing to cover a story that had officially ended but had not actually resolved. They covered the retrials. They covered the hung juries. They covered the additional proceedings with a weariness that occasionally showed through the professional surfaces of their copy, the weariness of journalists who have been on the same story for years and who are beginning to understand that the story may not produce the ending that everyone has been expecting. They covered the eventual dismissal of the charges with a mixture of outrage and resignation that reflected the mixed emotions of a city that had been hoping for a different outcome and had gradually, over years of legal frustration, come to understand that the different outcome was not going to arrive. But the coverage of the case was not only about the legal proceedings. The newspapers had also been telling the story of the Swope family itself, the story of grief and betrayal, and the particular horror of discovering that a threat had been living inside the family circle. And that story had resonated with readers in ways that went well beyond their interest in the specific legal question of Hyde's guilt or innocence. Readers had responded to the Colonel, to the portrait the papers had painted of a self-made man who had built a fortune and given a park to his city and who had died, if the evidence was to be believed, because someone he trusted had decided that his fortune was more valuable than his life. There was something in that portrait that touched the anxieties and the values of a readership that was itself largely made up of people who worked hard and built things and trusted the people close to them and hoped that trust would not be betrayed. The Colonel had become, in the newspaper coverage of the case, a kind of civic symbol. Not a perfect man. The papers were not hagiographic about him. They acknowledged his eccentricities and his complicated relationship with his family, but a figure who represented something that Kansas City valued about itself. The self-made Westerner. The man who looked at land that everyone else considered worthless and saw in it something real and valuable. The man who gave something permanent and generous to his city rather than hoarding what he had accumulated. His murder, if it was a murder, was therefore not just a private crime against a private person. It was an attack on something that the city felt it had a stake in. This was the emotional logic that drove the public's engagement with the case. This was the reason that courtroom galleries were full every day of the trial. This was the reason that the newspapers could count on their coverage of the Swope case to move papers and generate reader response in ways that other stories did not. The case had touched something real in the city's sense of itself, had activated a kind of civic grief and civic outrage that the legal proceedings gave a formal channel for, but that existed independently of and prior to those proceedings. The social class dimensions of the story also generated significant reader interest, though they were rarely discussed explicitly in the newspaper coverage, because explicit class analysis was not the mode of American journalism in 1910. But they were present throughout. The Swopes were old money, or something close enough to old money to function that way in a city that was not quite old enough to have the real thing. They moved in the upper tier of Kansas City society. Their names appeared in the society pages. Their philanthropic activities were covered in the press. They were the kind of family that the city's middle class read about with a mixture of admiration and curiosity and the particular feeling of proximity to glamour that comes from living in a city small enough that even the very wealthy are not entirely remote. Hyde was something different. Hyde was a man who had married into that world rather than been born into it, who had arrived at the edges of old money through a marriage that the family had initially resisted and that had been surrounded by questions from the beginning. This narrative, the outsider who enters the charmed circle through marriage and then destroys what he was supposed to protect, was not unfamiliar to readers who had encountered it in novels and in the morality tales that shaped the cultural imagination of that era. Hyde fit a recognizable archetype. He was the interloper, the imposter, the man whose surface was polished and whose credentials appeared legitimate and whose manner was professional and correct, but whose interior was something entirely different, something that the people who should have seen it had somehow failed to detect until it was too late. This archetype was satisfying to readers in the specific way that archetypes are satisfying, which is to say that it provided a framework for understanding events that were otherwise difficult to process. If Hyde was simply an evil man who had concealed his nature behind a professional surface, then the horror of what had happened was comprehensible, even if it remained deeply disturbing. If he was a monster in disguise, then the failure to detect him was explicable, because monsters in disguise are by definition difficult to detect. The alternative, which was that he was an ordinary man who had made choices that ordinary men sometimes make when money and opportunity and the gradual erosion of moral constraint converge in a particular way, was considerably more disturbing. Because that alternative raised the question not of how you identify the monster among you, but of how you understand the conditions that produce the monster, and that was a question the newspapers and their readers were not, in 1910, particularly equipped or inclined to engage with. The coverage of Frances was more complicated, and it evolved in interesting ways over the course of the investigation and the trials. Initially, the press had treated her with a sympathy that reflected the archetype of the deceived wife, the woman who had trusted too much and had paid the price for that trust. She was portrayed as a victim, alongside her uncle and her nephew, of Hyde's cold-blooded calculation. The fact that she was defending her husband did not initially disrupt this portrayal, because wives defending their husbands, however guilty, was a well-established social script that the reading public understood and for which it had a ready framework of interpretation. As the case went on, and as the evidence against Hyde accumulated and became more difficult to dismiss, the sympathy in the coverage of Frances became more complicated. Questions began to appear, at first obliquely and then more directly, about what Frances had known and when she had known it. The question of spousal knowledge is one that criminal cases involving domestic murder regularly generate and rarely resolve, because the interior of a marriage is the space that is least accessible to the outside world, where the most significant events occur without witnesses and where the truth is known, if it is known at all, only to the people inside the marriage itself. There were readers who believed that Frances must have known that the pattern of deaths and illnesses was too clear, too consistent, too directly connected to her husband's actions for anyone living in the same house with him not to have recognized it. There were readers who believed this and who expressed that belief in letters to newspapers and in conversations and in the general murmur of public opinion that ran alongside the formal legal proceedings. These readers found it difficult to extend full sympathy to a woman who, they felt, had chosen loyalty to a killer over justice for her own family. There were other readers who understood the position Frances was in with the particular empathy of women who had lived inside marriages and who knew, from the inside, how the intimacy and the dependency and the love and the fear that a marriage can contain can make it genuinely impossible to see clearly the person you are most committed to. These readers extended to Frances the full sympathy of people who understood what it means to be wrong about someone in a way that has catastrophic consequences, who understood that the wrong can be genuine and not merely convenient, who understood that self-deception in love is not the same as complicity in murder. Both readings existed in the newspapers and in the public conversation, and neither one definitively prevailed, because the question of what Frances knew was never definitively answered. It remained open, suspended in the ambiguity of private knowledge that the public record could not penetrate, and it remained one of the most discussed and least resolved aspects of a case that contained many aspects that were discussed and unresolved. The medical profession's response to the case was its own separate thread in the city's processing of what had happened. Physicians in Kansas City and across Missouri were watching the case with the professional attention of people who understood that it was not only a criminal matter, but a matter that touched their entire profession at a foundational level. The patient-physician relationship is built on trust, on the willingness of a patient to place themselves in the hands of a physician and to accept that what the physician does with that trust is guided by the obligation to do no harm. The Swope case, if Hyde was guilty of what the evidence suggested, was a profound violation of that foundational trust, and the medical profession was acutely aware of what that violation meant, not just for the specific patients who had been harmed, but for the general willingness of patients everywhere to trust the people who were taking care of them. There were physicians who said publicly that the Swope case demonstrated the need for stronger oversight of the medical profession, stronger mechanisms for identifying and removing practitioners whose behavior fell below the standards of the Hippocratic tradition. There were physicians who said, more quietly and in more private settings, that the Swope case demonstrated something about the specific dangers of allowing financial interests to become entangled with medical practice, about the particular corruption that can occur when a physician stands to benefit financially from the death of a patient. These conversations were not unique to the Swope case. The tension between medicine as a calling and medicine as a business was a well-established feature of the professional landscape, but the Swope case gave them a specific, vivid, impossible-to-dismiss illustration. The women of Kansas City followed the case with a particular intensity that the newspapers noted and that reflected the specific relevance of the case's themes to women's daily experience. Women, in 1909 and 1910, were the primary caregivers in most households. They were the people who sat with sick family members and managed the practical dimensions of illness, and called the physician and trusted the physician's instructions and administered the medicines the physician prescribed. They were, in other words, the people who occupied the position of trust that the Swope case had shown could be so catastrophically violated. And they followed the trial with the attention of people for whom it was not merely an interesting news story, but a kind of professional education in the risks of the role they were required to play. Pearl Keller's testimony resonated with women readers in ways that the testimony of the chemistry experts and the financial witnesses did not. Pearl Keller was a woman doing a woman's work, doing it in the specific and demanding context of a household that turned out to contain something terrible, and responding to that context with a courage and a clarity that women readers recognized and admired. She was not a heroic figure in the dramatic, flag-waving sense. She was a working woman who had done her job well in difficult circumstances, and that was exactly the kind of heroism that women in 1910 were most familiar with and most prepared to honor. The Kansas City that emerged from the Swope case was in some ways changed by it. Not dramatically, not in the ways that historians record as turning points in a city's development, but in the quieter ways that significant events changed the texture of a community's self-understanding. The city was a little more careful, a little more attentive to the questions that money raises about the people who want it and what they are willing to do to get it. A little more aware that the respectable surface of a person's life is not always a reliable guide to what that person is actually doing. The park continued. The park, which was the Colonel's enduring gift to the city, continued to be what he had intended it to be. A public space, open and green and welcoming, a democratic counterpoint to the private wealth and the private grievances that had produced so much of the story that surrounded its donor's name. People walked in it and picnicked in it and let their children run across the grass, and gradually the specific details of the Swope murder case faded from the forefront of the city's awareness into the background hum of local history. But the story was there. It was there in the library archives and the courthouse records and the old newspaper files. It was there in the family memories of the people who were descended from the Swopes and their contemporaries. It was there in the legal texts that cited the case for various procedural propositions. And it was there, in the specific way that true stories with unresolved endings tend to persist, in the back of the mind of anyone who had once known the full outlines of it and who found, years later, that the outlines had never quite faded. A city had watched a man be tried for murder and convicted, and then legally freed. It had formed its opinion and maintained its opinion, and watched the law's inability to sustain that opinion with the frustrated helplessness of a community that believes it knows the truth and cannot make the truth stick. And it had continued anyway. It had absorbed the experience and filed it and gone on with the ordinary business of being a city, which is always the ordinary business of continuing. The Colonel's name remained on the park. Whatever had been done to him had not erased what he had done for the city. The two things coexisted, as they tend to coexist in the complicated accounting of historical memory, where a person's legacy is composed of everything they were and everything that was done to them and everything that happened in their name, all of it inseparable, all of it part of the permanent record. Kansas City remembered the Swope case the way cities remember the things that disturbed them most deeply, which is to say imperfectly and partially, and with a selectiveness that emphasizes the parts of the story that are most useful for the purposes of the present moment. The details faded. The broad outlines persisted. The Colonel's name on the park persisted. And somewhere in the archive, if you knew where to look and had the patience to look there, the full story waited. It was there. It had always been there. And the people who found it, in whatever era they found it, tended to find in it the same things that the people of 1909 had found in it, which is to say a story about trust and greed, and the particular horror of violence committed in the guise of care, a story about what happens when the people who are supposed to protect us decide instead to harm us, a story about the imperfect but necessary machinery of justice and its encounters with human ingenuity and human darkness. The story was Kansas City's. It was also everyone's, because the things it was about, trust, betrayal, money, family, the failure of the people around us to see what is happening right in front of them. Those things belong to no single city or era. They are as old as human community and as current as this morning. And they will continue to be current as long as there are people who love and trust and can be deceived by those they love and trust. The colonel had known, at the end, that something had gone terribly wrong. He had said so, clearly, in the words that echo through the record of this case like a bell that will not stop ringing. He had wanted the truth to be known. He had reached for it with his last coherent breath and had sent it out into the room where people who would later testify to it were standing and listening and remembering. The truth had been known. The city had known it. The courtroom had spoken it. The law had struggled with it and had ultimately, in its procedural and technical way, been unable to fully account for it. But it was still the truth. And the truth, in this story as in all stories, is the thing that persists longest of all. There is something that houses know. Not in the way that people know things, not with consciousness or memory in any form that science can measure or philosophy can fully account for, but in the way that physical spaces absorb the events that occur within them and retain some quality of those events in their walls and their floors and the particular atmosphere of their rooms that sensitive people sometimes feel when they enter a space where something significant has happened. This is not mysticism. It is something closer to the recognition that a house is not merely a structure but a container, a vessel that holds the lives of the people who move through it, and that the lives of those people, their grief and their joy and their fear and their love and the specific, concentrated intensity of their most significant moments, leave something behind them in the physical world. Something that is not quite visible, but that is not quite invisible either. The Swope mansion had absorbed a great deal by the winter of 1909. It had absorbed decades of the colonel's solitary occupancy, the particular atmosphere of a bachelor's household managed with efficiency, but not warmth. The rooms that were elegant without being intimate. The spaces that had been designed for the display of wealth and the entertainment of guests rather than for the daily texture of family life. The colonel had lived there the way certain self-made men live in their houses, as though the house is a statement rather than a home, a declaration of arrival rather than a place of belonging. He had moved through its rooms with the quiet, contained dignity of a man who is entirely comfortable with his own company and who does not require the softening effects of domestic warmth to feel at ease in his own space. And then the family had arrived. Not all at once, not in any single dramatic reorganization of the household's character, but gradually, over the years when the colonel's age had begun to require more assistance and more company and the presence of family members who could manage the daily requirements of a large household that an aging man was no longer fully equipped to manage alone. The family had come in the way that families come to the houses of aging relatives, with a combination of genuine affection and practical necessity and the complicated emotional arithmetic of people who are both deeply fond of someone and also, inevitably, aware that the someone will not live forever and that what comes after their death will be shaped in part by the quality of the relationship that is being maintained now. The house had changed when the family arrived. The rooms that had been quiet filled with the sounds of people who are living together in the particular close, complex proximity of a family household. Children arrived, as children tend to arrive in the households of the women of the Swope family, with the disruptive, life-affirming energy of new people who have not yet learned to be quiet or careful or restrained by the weight of the history that the older people around them are carrying. There were meals together, the particular ritual of shared meals that is one of the primary ways that families constitute themselves as families, the daily performance of belonging that happens over food, and in the specific choreography of people who know each other's habits and preferences and the particular ways they hold their forks. There was conversation and disagreement and the low-level hum of multiple lives proceeding simultaneously in a shared space. And through all of it, Bennett Clark Hyde had moved. He had moved through those rooms with a quality that the people who later tried to describe it found difficult to characterize precisely. It was not unfriendliness. He was not the kind of person who made others uncomfortable with overt coldness or hostility. He was professionally charming. The kind of charming that physicians develop when they understand that patients respond better to warmth than to clinical distance. And he deployed that charm in the Swope household with the consistency of someone for whom it was a professional tool rather than a natural expression of feeling. He smiled at the right moments. He asked the right questions. He remembered the details of other people's lives and referred to them at appropriate intervals, which is one of the most effective social techniques available. The technique of demonstrating that you were paying attention, that the other person matters enough to be remembered. The family had received this charm with varying degrees of credulity. Maggie, the Colonel's sister and Francis's mother, had received at least. She had been watching Hyde from the beginning with the particular skepticism of a woman who has lived long enough to understand that charm and character are not the same thing, and that the most effective social performers are often the people whose inner lives are most completely hidden from the people around them. She had said he was after the money. She had said it, and she had meant it, and she had been right. And the months and years that followed the autumn of 1909 did nothing but confirm the accuracy of her reading. But in the rooms of the mansion, before the autumn of 1909, the charm had been the surface reality. Hyde had sat at the dinner table and passed the bread, and made conversation about medicine and current events and the particular topics that well-educated men and women of that era discussed in mixed company. And he had done all of this with such consistent professionalism that the resistance of the family members who most distrusted him had been difficult to fully act on. Because acting on suspicion requires being able to point to something specific, and the charm produced nothing specific to point to. The rooms themselves were grand in the manner of wealthy Midwestern households of the late 19th and early 20th centuries. There was a parlor of the kind that parlors were then, formal and slightly stiff, furnished with the particular upholstered heaviness of Victorian taste, a room for receiving guests, and for the specific performances of social life that required a setting more ceremonious than the kitchen or the sitting room, but less private than the bedrooms above. There was a dining room where the family gathered for the meals that were simultaneously ordinary and fraught. The meals where the passing of dishes and the clinking of silverware provided a comfortable cover for the silences that existed between people who were not saying everything they were thinking. There were the sick rooms. In a household that contained an aging patriarch and that, in the autumn of 1909, was hit by a succession of illnesses both genuine and induced, certain rooms had been repurposed for the specific requirements of nursing care. Beds were moved and furniture rearranged, and the paraphernalia of medical attendants. The medicine bottles and the basins and the clean linen stacked within reach, and the chairs drawn close to the bedside for the long hours of watching, had transformed rooms that had previously been part of the general living space of the household into the more specific, more serious space of the sick room, which has its own atmosphere distinct from any other domestic space, the atmosphere of heightened attention and lowered voices, and the particular quality of time that passes differently when someone you love is ill, and every hour feels both longer and more precious than ordinary hours. In those sick rooms, Hyde had done what he had done. He had stood at bedsides with the professional composure that everyone who observed him noted. He had administered medicine in the professional manner of a physician attending to a patient, the manner that implies expertise and care, and the particular authority of someone who knows what they are doing and why. He had moved with confidence and purpose. He had spoken in the measured, reassuring tones of a man who is in control of the situation and who wants the people around him to understand that they can trust him with it. He had done all of this in rooms where real human beings were lying in real vulnerability, where the specific horror of serious illness, the loss of bodily autonomy, the dependence on the care of others, the frightening closeness to the fact of mortality, had stripped away the ordinary defenses that healthy people use to maintain their sense of safety and control. He had moved through rooms where people were at their most open, their most trusting, their most completely given over to the belief that the person caring for them intended their well-being. And in that openness, in that specific and terrible vulnerability, he had done the things that the laboratories and the witnesses and the pattern of deaths and illnesses and the capsule fragments in the snow all pointed to. The house held all of this. The house had been present for every moment of it, the way houses are present for everything that happens within them, without judgment and without recourse, simply containing what occurs in its rooms and absorbing it in the way that physical spaces absorb the events they witness. After the arrests and the investigations and the trials, the question of what to do with the mansion became, for the Swope family, a practical problem that was also a profoundly emotional one. The house was real property, and it had real value, the kind of substantial financial value that wealthy families cannot simply ignore regardless of the emotional weight attached to it. But it was also the place where the Colonel had died, where Chrisman had died, where multiple family members had been made gravely ill, where the autumn of 1909 had unfolded in all its terrible specificity. It was the place where the trusted physician had stood at bedsides with his professional composure and had administered what the evidence suggested were lethal doses of strychnine. It was the place where Pearl Keller had watched and remembered, where Tom Swope had gone out into the snow and found the capsule fragments beneath the street lamp, where the ordinary domestic life of a wealthy Midwestern family had been transformed by the actions of one person into something that would be discussed and debated and written about for more than a century. The family dealt with the house the way families deal with places that have become impossible to live in without constant reminder of what happened there, which is to say they eventually stopped living in it. The transition was not immediate or dramatic. People did not simply walk out one day and not return. Life in the household continued in some form through the investigations and the early months of the legal proceedings, because life continues even in the most extreme circumstances, because the ordinary requirements of daily existence do not pause for grief or horror, because people still need to eat and sleep and wake up in the morning regardless of what the rooms they are waking up in contain in the way of memory and association. But gradually, as the legal proceedings moved forward and the family's situation clarified and the question of Hyde's guilt was transferred from the private sphere of family knowledge to the public sphere of the courtroom, the mansion became less a home and more a crime scene. Less a place where people lived and more a place where something had happened. And that transformation in its identity made it increasingly difficult for it to function as the former. A house where something has happened is not the same as a house where nothing has happened. This is not superstition. It is simply the recognition that human beings are deeply and unavoidably affected by the associations that a physical space accumulates, that we cannot fully separate our experience of a place from our knowledge of what that place has contained. The house passed through various iterations of ownership and use in the years after the case. The specific details of those transitions are less important than their general character, which was the character of a property that carried its history with it in ways that prospective occupants found difficult to fully ignore, and that therefore never quite returned to the ordinary status of simply being a house where someone lived. It remained, in the collective memory of Kansas City, the Swope Mansion, defined by what had happened within it rather than by its architectural qualities or its location or any of the other characteristics by which properties are normally identified and valued. This is a kind of afterlife that certain places acquire, an afterlife that has nothing to do with the supernatural and everything to do with the deep human tendency to remember places through their most significant events. The house on Elm Street in Dallas where President Kennedy dressed on the morning of November 22, 1963. The rooming house in Memphis where James Earl Ray fired the shot that killed Martin Luther King. The farmhouse in rural Kansas where the Clutter family was murdered in 1959. These places are not merely addresses. They are part of the geography of American memory, locations where history became personal in ways that reverberate long past the specific dates attached to them. The Swope Mansion was that kind of place on a local scale. It was the address that Kansas City people knew, the address that appeared in newspaper accounts, and that people pointed out when driving past, the address that carried within it the compressed history of what had happened there and what had followed. It was the place where Colonel Swope had been poisoned, if you believe the evidence. It was the place where Chrisman had died and Moss Hunton had died, and where multiple family members had been made gravely ill. It was the place where Pearl Keller had watched and Hyde had moved, and the ordinary domestic life of a wealthy family had been invaded and destroyed by a violence so quiet and so deliberate that it had taken months for the people closest to it to find the language to name it. The physical structure of the mansion itself was, in the way of substantial houses of that era, built to last. It was not the kind of construction that the 20th century's shifting real estate fashions would quickly render obsolete. It had the bones of something permanent, the thick walls and the solid floors, and the architectural ambition of a house that was built to stand for generations. And it did stand. It stood through the investigations and the trials and the retrials and the long decades that followed, changing hands and changing uses and accumulating the layers of paint and renovation and adaptation that all old houses accumulate, while remaining fundamentally itself beneath those layers. There was something almost defiant about its persistence. Something in the way it continued to stand and to contain and to be there, year after year, while the events that had occurred within it receded further and further into history, that suggested the physical world's particular indifference to the human dramas that occur within it. The house did not know what had happened in it. The house did not judge. The house simply persisted, as houses do when they are built well and maintained with reasonable care, through everything that the years brought and took away. But the people who walked through its rooms in the years and decades after 1909, the people who were aware of its history, those people brought their knowledge with them, and their knowledge changed their experience of the space in ways that were real and unavoidable. You cannot stand in a room where you know a person was poisoned and feel nothing different from what you would feel in a room where nothing like that had ever happened. The knowledge is with you. It is part of how you see the room, how you breathe the air in it, how you understand the quality of light that falls through its windows. You are standing in a room that was also another room, the room of an October evening in 1909, and the two rooms coexist in your experience in a way that you cannot entirely separate. The specific rooms where the deaths had occurred became the rooms that people wanted most to see and least to inhabit. This is a consistent pattern in the history of places associated with violent death, and it reflects something real about how human beings relate to mortality and to the physical spaces in which mortality occurs. We are drawn to those spaces by the same impulse that draws us to true crime stories and to the study of historical atrocity, the impulse to understand, to bear witness, to bring ourselves close enough to something terrible to feel that we have not entirely looked away from it. And we are repelled by those spaces by the equally real impulse of self-preservation, the recognition that some kinds of proximity are too costly, that there are things that can be known at a distance that cannot be fully survived at close range. The sick room where the colonel had lain, the room where he had taken the tablet from Hyde's hand, the room where his voice had found those words, "I wish I hadn't taken that damned medicine," and sent them out into the air where they would be preserved in the memory of everyone present and eventually in the permanent record of the case. That room was a specific physical space with specific dimensions and specific windows and a specific view of the world outside, and it had also become something more than a physical space. It had become the location of a moment in time that had consequences extending far beyond its walls, a moment that had set in motion investigations and trials and reversals, and the slow, painful destruction of multiple lives, a moment that contained within it the full weight of what trust can lead to when the person you trust has decided to betray it. The house survived the 20th century. It survived the transformation of Kansas City from the rapidly growing Midwestern metropolis of 1909 into the modern American city that it became, with its highways and its suburbs, and its new commercial districts, and the continuous renovation of its architectural history that all living cities undergo. It survived through a period when the specific events it had witnessed had receded from active memory into historical record, when the people who had known the Swopes personally were gone, and the case existed only in archives and in the accounts of researchers who came to those archives looking for the specific texture of a story that the official record preserved but could not fully animate. And in those archives, in the newspaper files and the court transcripts and the testimony preserved in the careful language of legal documents, the mansion was present too. Every account of what had happened in its rooms was also an account of those rooms themselves, of the specific physical space in which the events had occurred, of the way the house had contained and witnessed everything that passed within it. The archives were the house's memory, the external record of what its walls could not speak but had absorbed. If you were to walk through the rooms today, with the full knowledge of what they had contained, you would walk through a place that felt simultaneously ordinary and extraordinary. Ordinary because houses are houses, because the physical facts of walls and floors and windows and doors do not change their nature based on what has occurred within them. Extraordinary because you would know. You would carry your knowledge with you into every room, and it would change the quality of your attention, would make you look more carefully and breathe more slowly and feel, in some part of yourself that is below language, the weight of what you were standing inside. That is the gift and the burden of knowing history. The gift is the depth it adds to ordinary experience, the way it makes a house into a story and a room into a moment in time and a door into a threshold that once mattered in ways that most doors never do. The burden is the weight of it, the impossibility of not knowing once you know, the way the knowledge stays with you and colors everything it touches. The colonel had walked through those rooms when they were simply his rooms, when they were the rooms of a man who had built his fortune and given his park and was living out his final years in the quiet dignity of an old age that he had earned. He had walked through them without knowing what they would become, without knowing that the man who sat at his table would one day be accused of poisoning him in one of them, without knowing that his final words would be recorded and preserved and quoted in courtrooms and newspapers, and eventually in a story told to people who were not yet born when he died. He had walked through them as himself. As Thomas Hunton Swope, who had come to Kansas City in 1860 with money in his pocket and vision in his eyes, and the particular courage of someone who looks at what other people see as worthless and recognizes in it the seed of something real. He had walked through them as a man who had lived a full life, who had made his mark on his city in ways that would outlast him, who had been, in the final accounting, a good man in the ways that matter most. That is what the rooms contained, underneath everything else. Underneath the investigations and the autopsies and the expert testimony and the legal proceedings and the reversals and the retrials. Underneath all of the terrible machinery that the autumn of 1909 had set in motion, underneath all of it, the rooms contained him. They contained the life he had lived in them, the ordinary and extraordinary life of an extraordinary and ordinary man who had trusted in the way that good people trust and had been betrayed in the way that the best people sometimes are. The house knew that too. In whatever way houses know things, it knew that too. And if you listen, in the particular silence that old houses have, the silence that is not the absence of sound but the presence of something accumulated and persistent and real, if you listen carefully enough in the specific rooms of the Swope mansion, you can almost hear it. Almost hear the life that was lived there before the autumn of 1909. Almost hear the particular quality of an old man's voice, still finding its words, still reaching for the truth even as the truth was becoming the last thing he would ever reach for. Almost hear him. And then the silence again. And the house, persisting. There is a distinction that the law makes and that ordinary people find deeply uncomfortable. A distinction that sits at the heart of the American legal system and that produces, in cases like the Swope case, outcomes that feel like failures even when they are, in the specific technical sense that the law intends, exactly what the system is designed to produce. The distinction is between guilt and conviction, between what actually happened and what can be proven to have happened in a courtroom according to the specific rules that govern what evidence is admissible and how it must be obtained and presented, and what standard of certainty must be met before the law will say that a person has been established as responsible for a crime. These two things, guilt and conviction, are supposed to align. The entire enterprise of criminal law is built on the premise that they can be made to align, that the truth of what happened can be captured and represented in the formal proceedings of a courtroom with sufficient accuracy that the verdict produced by those proceedings reflects something real about the world, something that corresponds to actual events involving actual people making actual choices with actual consequences. The system is not perfect. It has never claimed to be perfect. What it claims is that it is the best available mechanism for making this alignment happen, and that the procedural rules it imposes, however frustrating they sometimes are in specific cases, exist to protect the integrity of the alignment over the long run. The Missouri Supreme Court's reversal of the Hyde conviction was a moment when the distinction between guilt and conviction became visible in a way that the public found almost unbearable. The justices were not saying Hyde was innocent. They were saying that the process by which he had been found guilty had not conformed to the requirements that the law imposed on that process, and that a verdict produced by a flawed process could not be sustained regardless of how well supported the underlying conclusion might be. They were saying, in the precise and technical language of appellate jurisprudence, that the rules matter even when the outcome produced by following them is deeply unsatisfying, and that the alternative to following the rules even when following them is hard is a system in which the rules only matter when they produce the outcomes that the public and the prosecution and the judge and the jury all happen to want, which is to say a system in which the rules effectively do not matter at all. This is the argument for procedural rules in criminal law, and it is a compelling argument, and most people who think carefully about it, and who are not personally invested in a particular outcome find it persuasive. The problem is that most people are personally invested in particular outcomes, most of the time, and the abstract argument for procedural integrity is very difficult to hold on to when the specific outcome that the procedures have produced is the release of a man who poisoned 3 members of his wife's family. The specific procedural errors that the Missouri Supreme Court identified in the Hyde trial were several. They were not trivial errors, in the sense that they were not the kind of minor technical slips that appellate courts routinely overlook under the doctrine of harmless error. They were errors that went to the fundamental fairness of the proceedings, errors that the court determined had materially affected the jury's ability to evaluate the evidence with the impartiality that the law required. One of the central issues was the admission of evidence from multiple deaths in a trial that was nominally about a single death. Hyde had been tried primarily for the murder of Colonel Swope, but the prosecution had introduced extensive evidence about the deaths of Chrisman Swope and Moss Hunton, and about the illnesses of the family members who had survived the typhoid outbreak. The theory was that this evidence was relevant to establishing a pattern, to demonstrating that what had happened to the colonel was not an isolated event, but part of a systematic course of conduct that was impossible to explain by any hypothesis other than deliberate poisoning. The pattern evidence was powerful. It was, in many respects, the spine of the prosecution's case, the thing that transformed the individual pieces of evidence from merely suggestive to collectively conclusive. Without the pattern, the strychnine in the colonel's liver was a disturbing finding, but not necessarily a proof of murder. With the pattern, it became part of a sequence of events that had only one coherent explanation. But the admission of pattern evidence in criminal trials is governed by rules that exist for important reasons. The rules reflect the recognition that evidence of a defendant's prior bad acts can have an overwhelming and potentially distorting effect on a jury's deliberations, that it can lead jurors to conclude that the defendant is a bad person generally, and therefore must be guilty of the specific act charged, rather than evaluating the evidence for the specific act on its own merits. The rules are designed to prevent convictions that are based on character rather than conduct, on what kind of person the defendant appears to be rather than on what the evidence demonstrates they actually did on a specific occasion. The Supreme Court found that the admission of the pattern evidence in the Hyde trial had not been handled in a way that fully satisfied these requirements, that the jury had been allowed to consider evidence about other deaths and other illnesses in a manner that had not been sufficiently cabined by instructions that would have enabled them to use the evidence only for its legitimate purpose. This was a real concern. It was grounded in genuine legal principles that had been developed over decades of appellate decisions addressing exactly this kind of problem. And the court's conclusion that the error was significant enough to warrant reversal was not an arbitrary or capricious one. But the reversal meant that a new trial was required. And the new trial, when it was held, ran into difficulties of its own. The practical challenges of retrying a case like the Hyde case were considerable. Witnesses who had been available for the first trial were less available for the second. Memories that had been relatively fresh in the spring of 1910 were less fresh by the time the retrial proceedings got fully underway. Some witnesses had moved. Some had become ill. Some were simply less willing to go through the experience again, to return to the stand and relive what they had observed and been part of and had tried, in the interval between the trials, to put some emotional distance from. The evidence was also more complicated to present the second time, because the defense had now seen the prosecution's entire case and had had months to prepare its responses to every element of it. The chemistry experts who would testify for the defense had had time to refine their arguments, to address the specific vulnerabilities that cross-examination had exposed in the first trial, to develop more sophisticated versions of the embalming fluid theory and the ptomaine theory and the other alternative explanations that they had advanced. The defense attorneys had had time to identify the specific weaknesses in the prosecution's case and to develop more effective strategies for exploiting those weaknesses before the jury. The first retrial produced a hung jury, 12 people who could not reach a unanimous verdict. This outcome was, in a practical sense, neither a conviction nor an acquittal. It was simply the failure of the process to produce a result, the failure of 12 people to find sufficient agreement about what the evidence established to deliver the verdict that the law required. It meant that the case would have to be tried again. The second retrial produced another hung jury. Again, 12 people. Again, no unanimous verdict. Again, the failure of the process to produce resolution. The pattern of hung juries was not random. It reflected the genuine complexity of the case and the genuine difficulty of the evidentiary questions it raised. But it also reflected something about the changed context in which the retrials were occurring, changed in ways that made conviction harder to achieve than it had been in the first trial. The public's attention, which had been intensely focused on the case during the investigation and the first trial, had begun to diffuse over the months and years of legal proceedings. The emotional immediacy of the events of 1909 had faded somewhat with the passage of time. The jurors in the retrials were people who were coming to the evidence without the same level of pre-existing emotional engagement that had characterized the public at the time of the first trial, and that different baseline affected how they processed what they heard and saw in the courtroom. There was also the question of money. The Hyde defense was expensive to mount, and it was mounted with a thoroughness that reflected the resources available to it. Expert witnesses cost money. Experienced defense attorneys cost money. The extended legal proceedings, stretching over years and through multiple trials, represented a financial commitment that most defendants could not sustain and that the Hyde defense sustained, in part, because the Swope fortune itself provided the resources through Francis's inheritance and whatever claims Hyde maintained through the marital relationship. This was one of the profound ironies of the case. The fortune that Hyde had allegedly murdered to obtain was, in part, funding the legal defense that was preventing him from being permanently convicted of obtaining it through murder. The money was simultaneously the motive for the crime and the mechanism of the defense against the charge, and this circularity was one of the aspects of the case that most infuriated the people following it, because it seemed to demonstrate, with particular clarity, the ways in which the legal system's outcomes are shaped by resources that have nothing to do with the truth of what happened. The prosecution, meanwhile, was not without its own constraints. The resources of the state are not unlimited, and a case that has already been tried once and reversed and retried twice without producing a final verdict begins, at some point, to compete with other demands on the prosecutorial budget. There comes a point in any extended legal proceeding where the authorities responsible for bringing it must evaluate whether continuing to pursue it serves the interests of justice or whether it has become a matter of institutional momentum, the continuation of a process because stopping it feels like an acknowledgement of defeat rather than because continuing it serves any purpose that stopping would not. The charges against Hyde were eventually dismissed. This happened not with any formal declaration of innocence, not with any judicial finding that the evidence had been insufficient or that Hyde had been wrongly accused. It happened in the quiet, administrative way that cases sometimes end when the institutional will to pursue them has been exhausted, when the prosecutors responsible for the case have concluded that the likelihood of obtaining a final, sustainable conviction does not justify the continued expenditure of resources required to pursue it. The dismissal was reported in the newspapers with a brevity that was itself a kind of comment on the state of public engagement with the case by the time it occurred. The elaborate, breathless coverage of the investigation and the first trial had contracted, over the years of retrials and hung juries, into something much more minimal. The story was still there, but it had lost the urgency that had characterized its early coverage, the sense that its outcome was going to tell something important about justice and about what kind of city and country this was. By the time the charges were dismissed, the story had become a kind of long-running disappointment, a procedural saga that had never delivered the clean resolution that everyone had been expecting, and the newspapers covered its conclusion with the same exhausted resignation that most people connected to the case were feeling. Hyde was legally free. He had never been finally convicted. He had spent time in custody following the first verdict, but that custody had ended with the reversal, and the retrials and their hung juries had not produced a new period of incarceration. He was a free man in the specific legal sense of that term, a man against whom no valid conviction existed and against whom no pending charges remained. What he was not free from was the consequence of what he had done, in the broader sense of consequence that extends beyond the formal sanctions of the law. He was not free from his reputation, which had been destroyed so completely and so publicly that it could not be repaired by any legal outcome, however favorable. He was not free from the knowledge of what he had done, assuming he possessed that knowledge in any form that a human conscience would recognize. He was not free from the particular kind of social death that public accusation of this magnitude produces, the death of the self that exists in other people's perception, the self that can walk into a room and be seen as a physician and a husband and a member of a community rather than as the man who poisoned his wife's uncle. The legal system had done what it could, or rather, the legal system had done what its procedural requirements and its institutional constraints had allowed it to do, which was not the same thing as doing what justice required, but which was the best available approximation of what a system designed to protect against certain kinds of errors can produce when it is operating in good faith according to its own rules. Whether those rules were adequate to the task of producing justice in the specific circumstances of the Hyde case is a question that the people most affected by those circumstances answered differently, and whose answer depended in large part on which specific failure you were most concerned about. If you were most concerned about the failure to convict a man who had poisoned 3 people, the rules had failed by preventing a sustainable conviction. If you were most concerned about the failure to protect defendants against the distorting effects of prejudicial evidence and prosecutorial overreach, the rules had succeeded by insisting on standards even when insisting was hard. Both concerns were real. Both failures were real. And the Hyde case sits permanently in the space between them, a case that demonstrates, with exceptional clarity, the price that a system committed to procedural integrity pays for that commitment, and the alternative price that would be paid by a system that was not. The attorneys who had argued the case on both sides were changed by it. This is almost always true of people who are deeply involved in major criminal cases, and the Hyde case was major enough to have changed everyone it touched. The prosecution attorneys carried the particular weight of a case that they believed they had proven, and that the legal system had nonetheless failed to sustain. This is one of the heaviest burdens available to a prosecutor, heavier in some ways than losing a case on the merits, because losing on the merits means the other side made a better argument, while losing on procedure means that the truth you established was set aside for reasons that have nothing to do with whether the truth was true. James Reed, who had led the prosecution with such skill and conviction, went on to a distinguished legal and political career that was shaped in part by what he had learned from the Hyde case. The case had taught him things about the relationship between truth and proof, about the gap that can exist between what everyone knows and what can be legally established, about the specific vulnerabilities in the system that allow that gap to be exploited by skilled and well-resourced defense teams. These were lessons that informed his subsequent work and that made him a more sophisticated and more realistic practitioner of the law than he had been before the case began. The defense attorneys carried their own particular weight. They had done their job. They had defended their client with the full professional commitment that the law required and that their professional ethics demanded. They had identified the procedural flaws in the first trial and had brought them to the attention of the Supreme Court. They had mounted effective defenses in the retrials. They had, in the formal legal sense, succeeded. And yet the success sat oddly with them, or so the accounts of people who knew them suggest, because they were men who understood the evidence as well as anyone and who knew, in the private spaces of their professional judgment, what that evidence indicated. Winning a case is not always a simple pleasure. Sometimes winning a case is the most complicated professional experience a lawyer can have. The jurors from the first trial, the 12 men who had deliberated for 3 days and returned the guilty verdict that was subsequently overturned, were perhaps the people who felt the reversal most acutely. They had done what they were asked to do. They had listened and evaluated and debated and reached a conclusion that they believed was supported by the evidence. And then the Supreme Court had told them that the process in which they had participated had been flawed, and that their verdict, however sincerely reached, could not stand. This is a particular kind of experience that has no fully adequate response, because the jurors had not made the procedural errors that led to the reversal, and yet the reversal undid what they had produced, and there was no mechanism for the system to acknowledge their sincere effort while simultaneously correcting the process that had produced it. One of the jurors, the one who had later told the newspaper that Hyde's own testimony had convinced him, was asked about the reversal in an interview conducted some time after the Supreme Court's decision. He said that he understood the legal reasoning. He said that he could follow the argument for why the procedural rules mattered and why the court had done what it did. And then he said, quietly, and with the resigned clarity of a man who has made his peace with an outcome he does not fully accept, that understanding something and being satisfied by it are not the same thing. He was right. They are not the same thing. In the Hyde case, perhaps more than any other case in Kansas City's legal history, demonstrated the distance between those two things with a precision that left everyone who had been involved in it changed in some permanent way by the demonstration. The law had spoken. It had spoken multiple times, in multiple registers, in the contradictory and recursive way that law sometimes speaks when a case is complicated enough to expose the genuine tensions within the legal system rather than simply testing its capacity to handle clear-cut situations. The first verdict had spoken. The reversal had spoken. The hung juries had spoken, or had declined to speak, which is its own kind of statement. The dismissal of charges had spoken, in the quiet, administrative voice of institutional exhaustion. And through all of it, underneath all of it, the truth had remained what it was. The strychnine in the colonel's liver had remained what it was. The cyanide in the capsule fragments had remained what it was. The pattern of deaths and illnesses that followed, so precisely the pattern of Hyde's access and Hyde's interventions had remained what it was. Pearl Keller's testimony had remained what it was. Tom Swope's account of the street lamp had remained what it was. Dr. Stewart's account of the typhoid cultures had remained what it was. All of it had remained. The law had moved around it and through it and had ultimately been unable to fully account for it. But the truth itself had not moved, had not changed, had not become less true because the law had failed to permanently enshrine it in a verdict. The truth of what happened in the Swope mansion in the autumn and winter of 1909 was not a legal truth. It was not the kind of truth that required a verdict to be true. It was the kind of truth that exists in the physical world, in the chemistry of tissue and the testimony of witnesses, and the cold logic of a pattern that has only one coherent explanation. It was the kind of truth that was there before the law looked at it, and was still there after the law had finished with it, unchanged by the legal system's inability to produce a final, sustainable accounting. And the people who had lived through it, who had been in those rooms, and had seen what Pearl Keller saw, and had smelled what Tom Swope smelled in the snow beneath the street lamp, those people carried the truth with them in the